Afternoon to our Facebook Live viewers. I'm very happy to be speaking to you all today about children's rights. My name is Elizabeth Nieuwoudt. I'm an advocate with Legal Aid and I'm the head of the Legal Aid South African Tembisa local office. This is our fourth Facebook Live broadcast focusing on human rights this month. March is Human Rights Month and we are using this time to spread awareness of our human rights and answer any questions you have about your rights. You can leave comments or questions about human rights below. If we cannot respond today during this video, look out for a message from us or a response in a future video. If you require legal advice, you can call our toll-free advice line on 0800 11 11. And if you didn't have time to write that down, here behind me is also the number. Weekdays between 7 a.m. and 7 p.m. If you cannot call, we can also call you back by sending us a please call me at 079 835 7179 and we will call you back. Like and share this video to spread the word on human rights. Okay, so let's take a look at what is children's rights or what is children's human rights. The source of that can be found in the document which I hope all of us know about, which is the Constitution. If you look at the Constitution, Chapter 3 of the Constitution is the Bill of Rights, and I'm sure everybody has heard about the Bill of Rights. And it is interesting that in the Bill of Rights, Section 9 deals with equality, and in that it says that you cannot discriminate against somebody based on their age. And Section 24 says that everybody is entitled to a clean environment or an environment that's not harmful or healthy or unhealthy. And Section 27 says that everybody is entitled to healthcare, food, water, and social security. But it is interesting that the writers of the Constitution actually thought that children are so important that they gave them their own section, that being Section 28 of the Constitution, that says that every child has a right to certain things. And it will be interesting if we go through the rights that you see those rights in Section 9, Section 24, and Section 27 are actually also given to children exclusively. So again, one can see that in terms of human rights and in terms of the Constitution, children are given a special place and special rights in terms of how we protect them and how we work with them. So if we look at the first part of Section 28, it says that every child is entitled to a name and nationality from birth. Now, unfortunately, it is a reality of our society that some people don't register their children at birth. And I think one will know that as adults, sometimes if you lose your ID, how difficult it is to just function in the society without an identity document. And imagine if your parents fail to register you as a baby and you are 12 or 13 or 14, they are nowhere to be found. And now all of a sudden you want to go to high school, you want to write matric exams, you want to go to university, and now you cannot have identity document because nobody registered you at birth, which in terms of the Bill of Rights is a fundamental right that children has. And this is actually where legal aid can play a role, because we can help that child by bringing an application to the High Court to get a birth certificate. Unfortunately, fortunately, the internal procedures of the Department of Home Affairs does make provision for the issuing of the birth certificate at a later stage, but sometimes there's little hurdles that one needs to cross, and some of it is because when maybe one of the parents are really missing, the child doesn't know where the parent is, he's been raised by a family member, and they now need assistance. So that's why I say luckily we can then at Legal Aid, we can help that. We then go to the second part of Section 28 that says the child is entitled to family care or partial care, alternative care. Now again, the Constitution and the legislatures or the people writing all the acts didn't stop there. They went and they wrote a wonderful piece of legislation which is called the Children's Act. And you'll see if I do like this, it's quite a thick document. And again, it's just how the people that wrote the act took 10 years to write this act, and they had many obstacles to come or to overcome to get this there's 305 sections plus regulations into being. And if it comes to that second part of Section 28, which I was talking about family care, parental care, and alternative care, that is where the Children's Act plays a role, because the Children's Act deals with that. It deals with, say, for instance, children or child-headed households. So if there's no parent left or no adult left to look after children, the Children's Act says that, well, in terms of the Constitution, you're righted to family care, or alternative care, or parental care. But if we cannot have a parent looking after you, then if there's an older sibling, 16 or older, then this Act makes provision that there can be structures be put in place for children to look after their own siblings. So again, in terms of the Children's Act and the family care, we also, as legal aid, we can play a role in a children's court where children are being, say, removed from their family care, to see that that is necessary. So we can play a bit of a check and balance role to see that the removal was indeed necessary. Or if there's reunification that can take place, we can also then make sure the child's rights are protected in that process. Then there's the third section of Section 28 talks about that the child is entitled to basic nutrition, shelter, basic healthcare services, and social services. And I think, unfortunately, in South Africa, in the current sort of economical situation we are in, that is something that I think we are struggling as a society to get to. Basic shelter, basic nutrition, healthcare, and social services. I know from my own experiences, Department of Social Development, sometimes their resources are also stretched to get to all the needy children and to render all the services. But in terms of the Constitution, the children are entitled to at least basic nutrition, shelter, and basic healthcare. Then the fourth one of Section 28 deals with children have the right to be protected from maltreatment, neglect, abuse, and degradation. Now, here again is where the Children's Act came into play, and especially the Children's Court. And again, this is where legal aid plays a big role, in that we assist children that goes through the Children's Court process, because unfortunately, these children do need separate protection, because you'll find in the Children's Court that if they are removed from their parents' care, the parents will, and I've been doing children's work for almost 13 years, and I have not come across a parent that come to court and say, oh, no, yes, no, that's true. No, I did that to my child. And unfortunately, we then need to protect that child from the parent, because they want their child back. So our role is to make sure that the child is protected in that process, but also to maybe just keep an eye on the social worker that does the investigation, to see that a proper investigation is done and that every factor is looked after, because sometimes children are not removed because of neglect or abuse. It's just parents going through a bad space, and instead of just removing a child, maybe just help them to overcome that bad space that they are in. So it's for also us as legal aid, and our role in the Children's Court is just to see that sort of the process goes well. But it's also, I think, hard to sometimes hear the stories that the children tell in terms of what their parents do to them. And if you look at the Children's Act and also later at Section 28, it says a child has the right to participate. And I think in terms of the Children's Court, there where the child participation is so important. Because in that process of protecting the child, one must hear the child. Because the child also has a story to tell. We cannot just listen to what the parents the whole time says. We must say, okay, what is it? What do you say? How did you experience this? What do you want? And then the Children's Act in terms of Section 10 says that a child of a certain age, maturity, or stage of development, his or her opinion must be listened to, and they have the right to participate in that. And again, that's where legal aid plays a big role. Our role has also been confirmed by the courts to say that, yes, we are in the best position to represent the child. Because why? We're not being paid by anyone. We are impartial, because unfortunately in these kind of situations and court cases, the child are tainted by the issues between the parents, and usually one of those issues are money. So if whoever holds the purse strings are the one sometimes that is in a better place to run the litigation. And that's what's nice about legal aid. We don't have to worry about who pays for us. We are just there to fight for the child. I think Judge Satchwell, in one of her judgment of Sollard versus Ard, used a beautiful picture of a boxing ring. And she says, as if you represent a child, you are standing squarely in the corner of that child, and you are fighting for the child. And as legal aid, because we are not constrained by who's paying our bill or who must we favor, we can stand squarely in that corner and we can fight for the child. Then the next one is protected from exploitative labor practices. Now, I think one, again, flowing from the Constitution, we have all the labor legislation that deals with safety in the workplace, who can work and who cannot work. But I think, unfortunately, we are sometimes naive. I think that children might not be exploited. But I was watching her on CNN the other day, and they have this freedom project on slavery and people being freed from slavery. And I think sometimes we think that slavery, it's 21st century, and who's in slavery and who's a slave. But it was absolutely amazing to see that, and it was children, all boys of 6 and 7 years old, that were working on fishing boats. They were not going to school. They were beaten. They were barely given food to eat. And that, again, I think the lady that was talking on the program, she said she finds it difficult not to judge because it is a social problem, but it is not an acceptable social problem. And I think sometimes in South Africa, we maybe also think that, but there's not children that works in or that are not exploited, but they are. I think you just have to maybe drive in your car and to an intersection and you see somebody standing with a child. Is that child not being exploited? It's a question to be asked, maybe not now for discussion, but I'm sure it can be something, a child being exposed to circumstances that might not be to his or her benefit. And then the next one is to say that children are not required or permitted to perform work which is not appropriate for a child of that age, or that will place the child at a risk. Now, I was immediately thinking, one day I was representing a child, and this child phoned me to say that no, but I must talk to his parents because they closed his cloud account. So his iCloud account. And I had to giggle by myself to think, okay, but I don't think that is what, that is the right that is protected, So when I was reading this, I think this does not include where your parents ask you to do the dishes. That is not what I think the Constitution is trying to stop. If it's your chore to make up your bed or to do the dishes or help your mother to carry in the groceries from the car, this is not what they're talking about. But I think this is where the child is being used to do adult work, which might place that child in a risk. That is what they are talking about. So no, this is not for the children to run to their parents with the Constitution and say, look, mommy, you cannot ask me to do this because it's not age appropriate. Then the other one, I heard my colleague earlier in the week maybe touched on this already, but Section 28 says that also that children should not be detained. And if they are detained, it must be the measure of last resort. And luckily, again, linked to that, we have a Child Justice Act that says how the court must deal with a child. So a child cannot be arrested and just put into jail with adults. If they need to arrest him, there's certain ways that the child needs to be protected and needs to be dealt with. Then again, I think the very last section of Section 28.1 talks about that the child is entitled to have legal representative assigned to him or her if otherwise substantial injustice would occur. And this again is where legal aid plays a big role in terms of providing that legal representation for the children. To say, okay, here's somebody to represent the child. You don't have to go and fight to appoint somebody. There is somebody that can help the child. It is interesting, what is a substantial injustice? It's one of those terms that you sometimes as a lawyer would go, okay, what do they mean by, what is a substantial injustice? Luckily, again, the courts have thought about this for a while, and I think the most appropriate one for me, and the one that describes it the best, is to say that a child is entitled to legal representation where his or her voice will be drowned out by the warring voices of his parents. And it is unfortunate, not a rare occurrence that children's voices are crowded out by the parents' voices. I recently represented 2 children that for 5 years their parents have been fighting about should they see their father, should they not see their father, how should they see their father, for how long, how many days. And it was only at the end, towards the end of the case, that we got involved. Just to say to the court, but these poor children have now for 5 years been saying the same thing over and over and over again. Why has nobody just listened to the children? And there's where the child's lawyer or the legal representative plays a big role to say, but hey, people, you listen to the adults the whole time, but why can't you just listen to the child? And I found that a lot of times, especially these children that has been caught up in these battles for such a long time, it's so empowering for them, because all of a sudden they feel, but I'm not like the puppy that everybody strikes and then say, oh, go and sit in the corner. I'm actually a person onto my own. I have a dignity. I have worth. Because then there's nothing. Unfortunately, the psychologists and the social workers that tell you that these children, a lot of times, I feel that it's their fault. The fact that their parents are fighting or things are not working out, it's not the parents. I feel that they did something wrong. That's why these things are going on and on. And that's why it's important for us then to give those children a voice, to make sure that they are heard, and not be just looked over. Then the subsection 2 of section 28 talks about, in all things, the child's best interest is paramount. And it says in every matter concerning a child. So it doesn't limit it to say only in this kind of matter, or only in that kind of matter. So when it comes to, let's use an example of a child of a certain age wants to change his or her name, because you get that a lot. The child is born with this or given a surname at birth, and then later on they think, but I'm not that person anymore. I see myself as Elizabeth Botha now, not Elizabeth Nieuwoud now. So, but I now want to change my name, but now I'm still a child. So, and then everybody would go, no, but you're not still a child. You cannot change your surname. But the Constitution says, what is the test here? The test is, what is the best interest? So, and also going back to the Constitution that says that everybody has a right to a name, to identity, not to be discriminated based on a name or gender. So that's the test. What is in the best interest of the child? One also nowadays deals with a lot with children that are transgender. So that issue also comes up to say, okay, what is in the best interest? And I think their society still wants to cling to sort of rigid, conservative kind of guidelines. But no, you're a boy. You must be a boy. You cannot be a girl, even if in yourself you feel yourself a girl. And what is the test? What is in the best interest of the child? And unfortunately, we have had cases in the past where social workers actually wanted to remove a child because it was a certain gender, the child, and he saw himself as a girl. And his mother was quite willing to treat him as a girl. And the social workers actually removed the boy because they felt that the mother was not acting in the child's best interest, which is scary if we think that, that is the conservative sort of guidelines out there. So that's not the guideline. The guideline is what is in the best interest. And I also say that if I go then to the Children's Act, is that before all the wonderful people that took 10 years to write this act, before this act came into effect, this whole concept of what is in the best interest was this vague thing that sort of hang in the air, and everybody used it for their own purpose. And I always used to say that it is that one thing that if you now ran out of any argument and you can't say anything more, then your last resort is you pull that rabbit out of the hat, the best interest. So it was very misused term, but luckily the people that wrote the Children's Act, they were clever enough to now try to limit that. So in terms of Section 7 of the Children's Act, they've now given us a nice, I always call it a checklist, to say what is the best interest of the minor child. And they have a whole list of, I always have to count it because I can never count quickly enough to see how many, but it's about 14 sort of little items that one can look at in terms of what is in the best interest of the child. And both the Children's Act and the Constitution use words like paramount. In Section 28 of the Constitution, they talk about paramount. And in Section 9 of the Children's Act, they also talk about they actually say the best interest of child paramount. And then they say, in all matters concerning the care, protection, and well-being of a child, the standard that the child's best interest of a paramount is important. And so a while ago, one of the presiding officers in the Children's Court, she explained it nicely to say paramount is almost like a paramount chief. That's it. That's the top, that's the final say. So it's paramount. So after we've now discussed a lot of other things, in any kind of case, the one question everybody must come back to is what is in the best interest of the child. So if it's about, and what's interesting, and I think what is important to remember, if I go back and I want to reiterate that, to say it's not only in care and residency disputes what is in the best interest. The Constitution says in all matters containing to a child what is in the best interest of the child. So that is not only a thing that I think as lawyers, we tend to use that in care and residency issues because that's like the habit. But if you look at the Constitution, it says in all matters, the best interest of the child must be taken into consideration. One of the, if I can perhaps just briefly look at the Section 7 of the Children's Act, they talk about to look at the relationship of the child between a parent and also not only a parent, because I think nowadays one must be careful to get stuck on a parent, because a lot of children nowadays don't have parents anymore, but they have caregivers that look after them. So the Act also takes that into consideration to say, to determine what is in the best interest, one of the things we must look at is at the nature of the relationship between the child and the parent and the child and that caregiver. So that's one of the things. The other important criteria that Section 7 puts out there, which I think nowadays is becoming more and more important, is the attitude of the one parent towards the other parent pertaining to their child, or the one caregiver towards the other caregiver towards the child. One would say, oh yeah, but attitude is also it's such a difficult thing to to define. I think if as a child, when you were naughty, your father or your mother would say, I don't like your attitude, you must change your attitude. So what is attitude? But I think that one of the psychologists one day puts it nicely to say that attitude is more permission. I, the one parent, give you permission to love your other parent. I, as caregiver or alternative carer, give you permission to love the other person in your life or other persons in your life, the whole family. I mean, remember, a child is not always just a child and a parent. There's a child and a granny, a child and an aunt. It's a child in a bigger family structure. So that thing of, I have an attitude of, it's okay, you can love the other people in your life. So that's very important. And a child, I think like all of us, if you have friends, you have a loyalty. And we are human to say our loyalties sometimes are better or bigger towards somebody than others. And a child is exactly the same. You'll find that a child will have a loyalty towards one. And if there's not a permission to say, oh, but I can love the other one, the loyalty is going to go towards the one parent. Then also section 7 that talks about the best interest says the capacity of the parent or the caregiver to provide in the child's emotional and intellectual needs. And I think that's a difficult one, because how do you determine capacity, intellectual and emotional needs? Does it mean now that if you as a parent are mentally not okay, that you cannot raise a child, must we remove your child? I don't think that is what it means. I think it is more a question of looking at where there is a child that's in need of care or a child in a conflict situation. What is the capacity of the one parent about the other to take care of the child in specific circumstances, both intellectually and emotionally? The other in terms of what is in the best interest of the child, what will be the effect be on the change if you move a child, if you change the child's circumstances? What will be the effect be on the child of those changes? A lot of things is, are you going to separate them from a sibling maybe if you change the circumstances? Maybe they're at the age, I'm sure, I don't know who had brothers or sisters, but at a certain stage, you and anyone to kill your siblings. So is it at that stage? So they might not be too, it might be a good thing to separate them for a little while and that they don't kill each other. But what is the effect of the change going to be? The other thing which I think nowadays is becoming more and more something that needs to be considered in terms of what is in the best interest of the child is the removal of the child in terms of distance. I think we find it more and more that as circumstances change in the country, but I think also in the world, parents move to different countries to find work. I was having a conversation with a gentleman the other day, and he says, at the end of the day, if you can work in Saudi Arabia and that's where you can get money, that's what you need to do. So, but now say if that parent wants to take the child with, what is the effect going to be in terms of that distance that you're going to put between the child and the, let's call it the left behind parent? So I was in the Cape a while ago, in Cape Town, and it seems it's a big issue. I don't know if it's because of the nature of Cape Town. Okay, maybe there's a lot of international movement or people moving in and out. So they have a big problem with parents want to relocate to another country. And it's always not the easiest because I think nowadays also with things like, I'm talking on Facebook, with Skype, FaceTime, I don't know what all kinds of things you have nowadays that you can communicate with somebody in another continent on a different side of the world. But still, talking to somebody over a live stream or a video call is not the same as having somebody in front of you, giving them hugs and kisses. So yes, I think it makes it easier, but it's not always the best, but it's something that can be taken into consideration. Then the other, in terms of what is in the best interest of the child, referring again to the Children's Act and going back to what Section 28 of the Constitution says, is that the need for the child to remain in the care of his parents or family, or have connection with his family and so with culture. Again, a very controversial thing, so I will tread carefully. But this especially comes into play with the adoptions. You get a lot of inter-country adoptions where South African children are removed to Portugal or Spain. And then this big debate comes about, but aren't you removing a child from a culture, from a country and what about the fact that the child will not know that culture, will not know the people from South Africa? So it's a very controversial thing, but I always say at the end of the day, going back to Section 28 of the Constitution, going back to Section 9 of the Children's Act, the question here is what is in the best interest of the minor child. Not what is in the best interest of the adults, but what is in the best interest of the minor child. So I say that I will tread carefully on that one. Then again, one of the other things, but that also links to Section 10 of the Children's Act, it says that a child must be a child's age, maturity, stage of development, gender background, and all other things of the child must be taken into consideration. So it's always easy to say that if we work with children, we tend to focus on the parents on the one side, because we must look at who's the parents, but we almost look who's the child. And because if we understand who is the child, then we can protect that child best. So we'll have to look at the child's age, stage of development, gender, the circumstances from where the child came, to say how best can we protect this child to do whatever we have to decide we want to do with the child. Then the child's physical and emotional security, and then also other thing that's I think quite obvious, or two of the things, is if there's a chronic illness or a disability. I think again disability is difficult circumstances sometimes, because you want to protect the child, and then sometimes it will mean you have to move the child maybe from circumstances where he's loved and cared for, but the circumstances is not for his disability. So again, there's a fine balance of, yes, I love my child and I want to care for my child, but is the circumstances necessarily in the best interest of the minor child? Mm-hmm. And chronic illness also, again, it's something that just to not lose focus. The focus is here on the child, not on the parent or the granny or the aunt. Is the focus on the child. So what is in the best interest of that child, not based on the chronic illness of the child. The need for the child to be brought up in a stable family environment, as closely resembling a usual family environment. So yes, one would be if we live in an ideal world, everybody will have what the Americans call the white picket fence, and and 1.4 children and a dog and a cat. But we don't live in that world. We live in the real world where we don't have we'll have white picket fences with dogs and cats. But what can we do to give that child the circumstances as near as to that? And if we have to remove a child or place a child in alternative care, yes, sometimes we place, I think everybody then frowns and says, okay, the child is going to a children's home. And then everybody is upset and everybody wants to cry. And then I think everybody sees Annie. I don't know who remember Annies that live in the, in the orphanage, and there was the horrible stepmother that looked after them. But I mean, that's not the children's homes of today. The children's homes of today has house mothers, house fathers. So we try to give the children a family environment as close to as a normal family environment. And also one must be very careful, I think, also to give this the normal, what is normal for me, what is normal for you. That's also to be careful to cling to our normal instead of just looking again. Don't focus on what your normal is or what my normal is. Let's focus on what is in the best interest of the child. Then I think the other one which is important here, but it's also sort of logical, it's the best interest for the child to protect from physical or psychological harm that will lead to exploitation, exposing to violence, maltreatment. One would think that's kind of logical, but sometimes again you think that that circumstances sometimes lead to children being exposed to things that are harmful, and that parents sometimes out of desperation expose their children to, and they don't, again, it's out of desperation. And again, to protect the child, the balance is to protect the child, but still say for the mother and the father, but it's okay. We're going to help you to protect your child, but still taking into consideration your circumstances. Then the one that is the sort of that I love to use is to say that it is not in the best interest of the child to be exposed to a lot of legal administrative proceedings. You will find if you work in the field of family law, that I'm sure some people that are watching do, in these kind of matters where children are exposed to a lot of court cases, a lot of experts, a lot of administrative actions, and it's not in the best interest, and that's what the Children Act says. It's not in the best interest of a child to be exposed to continuous assessments, continuous. I usually, when I start consulting with a child or children in these circumstances, the first thing we do is we start counting and usually when I consult in Afrikaans, so we will talk about the ooms and tannies. So how many, in English it doesn't sound that nice, but how many people have they been exposed to in this eventually ending up in my office? And it'd be amazing that some of these children are like 6, 7, 8 people later, unlike the 9th person or the 6th person that they've been exposed to, that they must continuously tell the same story that they've been telling. And then also a child at some stage, and you find that a lot of children that has been exposed to sexual abuse or physical abuse, they sometimes then come to a point that say, well, I'm not going to talk anymore, because why must I repeat all of this over and over and over again? Because nobody, clearly, if I have to repeat it 5 or 6 times, nobody is believing me. So I'm going to stop now. And I think that way the criminal system fails the children, in my opinion. Sure, somebody's going to throw stones at me. But I think that our criminal system, in terms of prosecuting the sexual offences, they don't take that into consideration. I know they try to have the sexual offences court. They try to push the cases to finalization, but you still find that a lot of times that child testifies only after 2 years, 3 years down the line. And that, in my opinion, is not protecting the rights of the child. Yes, we need to protect the rights of the accused also. So I think I've suggested to somebody a while ago that they must do like a doctorate on this to see because isn't it a balance between 2 rights? I mean, as an accused, I have rights in terms of the Constitution, but the child in terms of the Constitution has also have rights. So whose rights are more important? And then it depends on who you ask. A while ago, I was at a meeting of the workers of Childline. And if you ask them, they will just like draw a line through Section 35 and say, okay, no, the child's right is paramount. But I mean, they work with horrendous and horrific stories that come across their desk. So for them, this whole thing of a fair trial and speedily trials and not being this, not being that, they don't understand that in context of the protection of the child. And again, but I think there's a lot of people that, and even the children would say, but you say I have rights and you say I need to be protected, but now you put me through a 2 or 3 year court case. How is that protecting my rights as a child? But as I say, I did suggest to somebody that it might be a good doctorate or master to do about those 2 rights, those sort of conflicting rights. I think also one thing that people tend to ask me if they see me about children and when must children be listened to. For some reason or another, the age of 12 is the urban legend that is out there, which is not true at all. In terms of the Children's Act, Section 10 of the Act only says that a child must be heard, or the voice must be taken into consideration, taking into consideration the child's age, maturity and stage of development. So that age in the Children's Act is not defined. So a child of 6 can have a voice and an opinion and a wish that a court must be taken into consideration. But the question there is more the maturity. A child of 6, you might get a child of 6 that's very mature, but you might also get a child of 6 that is not so mature. Then the court will say, no, well, yes, I hear you, but I cannot follow your wishes because you're not old enough to that we just blindly follow your wishes. So again, I think because actually the other day I had a boy that asked me that. So I was consulting with him and he said now somebody told him that if he's 12, then he can choose where he wants to stay. So even in the children's minds, in the schools out there, I don't know where they hear it, but they have their own ways of hearing things. They have this belief that it's 12. If you look at the rest of the Children's Act, I think where it comes from is in terms of the Children's Act, 12 is the age that you can consent to medical treatment. You can get contraceptives. You can consent to other medical treatment. So I don't know if the age of 12 maybe slipped through from those sections of the Act into this whole thing of a child being heard. Also, when you're 10, you must consent to your own adoption, or you have a say in your own adoption. And then you must be 16 for a child-headed household. So I don't quite know where this whole thing of 12 came in terms of a child being heard. Yeah, I don't know if there's any questions.
Could you just speak to a child being a person under the age of 18?
Okay, yeah, when we grew up, and I'm sure my colleague that's here near, we also, our age of maturity was 21. And then more or less when the Children's Act came into effect, which was now, I hope I'm correct, about 2005 or a bit later, they changed that to 18. If I remember correctly, it was also at that time a thing that the society, it wasn't practical anymore for the majority age to be 21, because you had a lot of child-headed households, you had a lot of children that were without parents. The whole idea of then waiting until the child is 21 was just, if I can use the word, impractical. So they made it 18. But I see nowadays I don't know, the children still have 21st parties. They don't have like 18 parties. So it seems that the 21st is still like the magical number. The other thing is, I think what happens nowadays, unfortunately, coming back to children and what we said, that children is entitled to sort of stability and being maintained and having food and clothes, is that you get a lot of children that are 18, but then they are still at school. Then the one parent would decide to stop by maintenance. Now you have the uncomfortable situation that child, being an adult, need now go to the maintenance court themselves. So, and the 18 it's good in terms of practicality, but it also places, I think, children, although they are 18, I don't know if they're mature enough to really take that kind of step. But yeah, it makes sense, and I don't think it's a wrong thing, but that is sometimes the anomaly that you sit with now. For some children, which are caught up in a lot of these conflicts, 18 is also a good age because it's not that far. So by the time that they are 18, they can actually say to the parents, just go away, leave me alone. Don't fight about me anymore. I will now decide. And then actually, just because they've reached that magical age of 18, nobody can say to them, but you're wrong, because you're now 18 and you're an adult. I think so all in all, the age of 18 is a good age of maturity because it just makes life for children much easier. Okay, so it seems I haven't said anything controversial because there's no complaints or anything rolling in. So thank you for joining us today. If you have any further questions, you can send us a Facebook message, or if you require legal advice, you can again call our toll-free advice line on 0800 11 weekdays from 7 to 7. And if you cannot call, you can send us a please call me at 079 835 7179, and we will call you back. And please join us again next week as we continue speaking about the rights of arrested, detained, and accused persons. And also send us your questions, and remember to like and share this video to spread the word about human rights. Thank you and goodbye.